Thanks, everyone. It's good to be here. For me, my first live in-person conference since the pandemic, and what a pleasure it is. Very grateful to my co-panelists, starting at the end, David Hunt, a colleague from Boyce Schiller, an arbitration specialist through and through, widely recognised for his up-and-coming practice across a breadth of investment arbitration, commercial arbitration, described in recent Legal 500 as an extremely clever lawyer, which I can say from my experience is an understatement. Philippa will need very little introduction to this room. One of the leading lights of the London arbitration world, leads the impressive and growing arbitration practice at Stewart's, sits on any number of ICC committees and sits very extensively as an arbitrator. And then somebody who probably will need an introduction to this room, John Coleman is a corporate and M&A partner at Addleshaw Goddard, based in London, but working extensively for clients on M&A transactions throughout Africa and the Middle East, and therefore a user of arbitration in the sense of advising clients at the transaction stage when arbitration may or may not be a good idea for them. And so, John, I'd like to start with you. I've certainly found in my career that corporate partners like you tend to like to avoid me, and that's only mostly due to my objectionable personality. I think it's also because arbitration is something you don't want to see happen, and I'm taken back to the days when I used to have transactional colleagues, and if you would go up to the sort of vaunted 28th and 29th floor and walk around as a litigator, you felt a little bit like the Grim Reaper walking around, and people would hover by their doors and wonder whose deal had just gone south. So it's very brave of you to come and share this panel with us. Can I ask you, just for our benefit, because we're looking, of course, at disputes that might be coming down the pipe in a few years' time, what is the state of the M&A market as you see it? And in particular, what are the sort of risks that are keeping your clients awake at night and that you're trying to mitigate in your agreements?
Of course. Good morning, everybody. Very nice to be here. So, anecdotally, it's been a really, really busy year for M&A last 12 months, which is great, obviously, for me. But it's borne up by the data as well. It's just a few stats, just so everyone's clear. Compared to the quarter of last year, which was the doldrums, we all thought M&A might be falling off a cliff due to the pandemic. Actually, we've seen a 92% increase in deal value and a 20% increase in deal volume, so compared to the this quarter last year. And an interesting stat I read over the weekend is that this is the 5th quarter in a row where we've seen deal values of over $1 trillion. And that's the first time that's happened since pre-2007. So I think the M&A market as a whole is in very good shape, which once again is great news for me, and hopefully, well, not hopefully, but may well be for you all as well. That growth is driven by the same factors we've seen over the last number of years, which is a lot of cash on balance sheet, cheap debt still available, and obviously now a bit more of a fear perhaps of that debt becoming less cheap, and so actually people trying to get deals done more quickly now while it's still available. There's also more mega deals we're seeing. So deal values of $5 billion plus have increased by 99% since this time last year, and 10 billion plus by 65% from last year. So I hate to shout statistics because a lot of them may be made up, but overall very good, very positive in terms of the M&A market. Sectors, the usual suspects, TMT, tech, for obvious reasons we're seeing. And as we all know, the pandemic has driven and probably just accelerated trends that were already underway. So if you're obviously investing in something like Zoom 2-3 years ago, you've borne the fruits of that now. Other things, pharma, obviously health sciences, etc., life sciences, sorry, healthcare, obviously all seeing very positive levels of activity. And even ones we might be worried about, like retail and consumer, has proven very resilient from an M&A perspective. And you only need to look at last week's takeover of Morrison's to see that in action. In terms of the risks that we as M&A lawyers are really looking to mitigate, and as it won't surprise you, they relate to the pandemic. And they relate to things like, obviously, compliance with the laws, particularly around things like health and safety. How has your business complied with all the various guidelines and rules and regulations that the governments around the world put in place to help protect employees and customers and counterparties? But more broadly than that, of course, we have things like the government funding schemes, and other schemes like furlough, for example, here in the UK. So have you, when you introduce your furlough scheme, complied with the laws, complied with the regs? Have you consulted properly with all your employees, for example? And they're the kind of warranties that we're seeing more and more in our transaction documents. funding. We all know we've had lots of various acronyms here in the UK, CBILS, CBBS, whatever they were, lots of these various funding schemes in the UK and in all jurisdictions around the world, helping businesses through the tough times. But all those schemes had conditions attached to them. They require compliance, whether that was in application, but also longer term reporting, etc. And so we're seeing warranties around those to make sure that the businesses you're buying have complied with those regulations and those obligations on them. There's also a few more unexpected, perhaps, warranties you might expect to see, things like tax residency of your employees and directors, because some of your employees and directors may well have been stuck in a different country for months on end, and therefore their tax residency may well have changed inadvertently. So we're seeing just very nuanced warranties like that, particularly when you're buying a business, say, from a founder or a manager-run business, an own business. Other things like business continuity, etc. Cybersecurity as well, obviously, because increased working from home and remotely, there's increased cybersecurity risks and data breaches, which obviously we've seen more and more of. And so, once again, an increased focus on those in our documentation. Another interesting trend, which is not pandemic related, but it was already mentioned earlier, is around things like ESG, sustainability. We're seeing lots more focus on that, particularly from financial sponsors, PE investors. And the interesting thing, I think, from my perspective, is this isn't just compliance with law. This is, making sure that people have in place the right procedures to manage things like the supply chains, climate change risk, etc. And very specific examples are, I'm looking at warranties, for example, that focus very much on making sure that business has altered its supply chain properly, and down to things like solar panels and cotton from the Xinjiang province due to, obviously, the problems there with the Uyghur population. So it can get down to quite minute detail, the risks that some clients are focusing on. I hope that was helpful.
Really helpful. And I'd never accuse you of making up statistics, John. We leave that to quantum experts, don't we? Philippa, what are you seeing in terms of, there's been a lot of expectation that we would see M&A deals fall over, and certainly anecdotally saw last year some deals really sort of failing to close and sort of real sort of sharp changes in valuation and people trying to find ways to get out of deals. But anecdotally, and from your experience and from what you're hearing, what's the state of our market in terms of actually seeing those disputes come to fruition and come into arbitration?
Thanks, Will. I mean, I think business hates uncertainty, right? So the advent of the COVID-19 pandemic meant that you had a lot of people who felt that what they had thought of as certainties were no longer certainties. And I think that's continuing. I mean, if we look at even the rhetoric that's going on at the moment about factories and energy usage and the risks of returning to a 3-day week, I mean, that's nothing that anyone would necessarily have predicted unless they were a real, Brexit skeptic like me. They wouldn't have gone there 2 years ago or 4 years ago or whenever. And so at the moment, I think there is still a sense of waiting for the other shoe to drop. There's a sense of survival being more important right now than necessarily pursuing claims. So for those deals that have closed, I think there's probably a period of assessment really before we will see that uptick in litigation. And I think, for those of us who worked through the post-financial crisis issues, they didn't really start to come to fruition for sort of 2 or 3 years after the position stabilized, because actually people were more focused on staying in business than they were on pursuing claims. That said, I think there are already claims around things like failures to make closeout payments or earn-out payments. There are claims, against retentions from the purchase price. And obviously, in what is a volatile business environment, it's quite hard to crystallize those claims from a financial perspective, at least. I mean, you can certainly point to the impact on the business, but the way in which you go about proving that to the required level, I think, is quite challenging. And the other thing I would say is that obviously, whilst there is a desire sometimes to kind of wait and see and kind of get to a point where you can crystallize the claims, what I find very often with warranty claims is that there's a shorter period within which those have to be brought than the limitation period itself. And so decisions are having to be made early from a sort of strategic commercial perspective as to whether or not to pursue these things. And my experience so far is that absent a sort of bet the company type situation, there's definitely a reluctance to enter into kind of big ticket litigation or arbitration at this point. As I say, survival is probably more important at this stage.
Thanks, Philippa. And David, I suppose the same question to you, but I know you've been heavily involved recently in a range of different kinds of sort of post M&A dispute, warranty claims, misrep claims, and the like. I mean, can you talk us through a little bit about what you're seeing, but also the sort of archetypes of the sort of disputes that come out of transactions?
So, so I think, I mean, of course, as Philip has already identified, disputes lawyers are a bit like the kind of undertakers of the legal profession. We profit out of disaster, and we're still profiting to some extent out of the disasters of the early 2000s. So my practice, because of that long tail, a lot of the stuff that I'm seeing relates to things that happened in, say, 2015, 2016. I've just finished doing a very large dispute about sale of a Brazilian retail company in a situation where the sale was carried through. A few years later, events started happening that indicated to the claimant that there had been misrepresentations as to the financial status of the business and the financial accounts that were warranted in the SPA. And it's only after a certain amount of time that you can start to see those problems coming through. So it's going to take, I think, a while for all the bad things that have been covered up in 2000 and 2021 to come out into the open. Another comparator, I just finished an arbitration against a state to do with regulatory changes, essentially, that it imposed on licenses coming out of its financial crisis in the early 2010s. And we said, well, that violated indemnities that the state had given in a privatization SPA. And again, that was a long tail, precisely because it took a long time for those kind of issues to flow out. I think there's some support you can look at. I think John's going to talk a little bit about W&I insurance. AIG produces an annual report looking at its WI insurance claims book. And for last year, by far and away the biggest amount of claims AIG had was for financial statement misrepresentations. So that gives you a little bit of a snapshot of what in 2020 was still engaging people in claims and disputes, albeit lots of W&I stuff, of course, doesn't end up in a dispute. But there are other things that are more urgent and more pressing, particularly in the context, say, of immediate attempts by parties to avoid closing their M&A transactions. So, the classic example of that would be, I think, most people will have seen, I think I'll probably mispronounce it, but the WEX case last year about interpretation of material adverse event clauses. I think probably a case everyone was hoping was happen. I think everyone got frightfully excited when the pandemic came, telling their clients all about MAE clauses, and then there weren't actually that many cases about it. And the WEX case probably didn't shed as much light as everyone hoped on the interpretation of those clauses. But that was a good example of how, in a moment of economic chaos, the buyer to the transaction was trying to put a stop on the deal and really looking for anything in the contract that would allow them to get out of what they thought. I suspect they may have changed their mind now, but what they thought at the time was going to be a disastrous deal.
Yeah, and certainly I've been acting for a seller in the last year in exactly that. And that's a sort of example, I suppose, of the sort of a dispute with a short tail, because it's a buyer simply saying, I've agreed to pay X for this business, but in light of the pandemic, I don't think it's worth X anymore, and buyers trying to find a way out. But if they signed up in a binding agreement to pay X, then there isn't necessarily a lot of debate, absent some creative lawyering. But you mentioned, David, the other scenario in M&A disputes, which is the dispute with a long tail and things revealed over time, and perhaps a buyer coming to the conclusion over a period of time that the thing they bought was not what they hoped it would be, and bringing claims. And as a seller in that situation, potentially you've walked away from a divestment some time ago. Questions are then being raised with the seller about points of detail, about their accounting policy, or potentially, as John mentions, we could be seeing points raised about their compliance with health and safety policy or tax indemnities. And that presents a difficulty for sellers in terms of really knowing how they are supposed to respond to that. And Philip, I don't know if that's something that you encounter on the seller side, that difficulty that actually you no longer know what is out there in this thing that you have walked away from.
Yeah, I mean, I think that's certainly a common problem. And from the selling side, I mean, anecdotally, you probably know where the bodies are buried, but the reality is that you no longer have direct access to that information. You may not have access to the people anymore. And so that does create an issue in terms of looking at the agreement that you signed up to and saying, well, are we caught by this warranty or not? And, what helpfully people like John do is try and, narrow the scope of those things so that there is a sort of accessible and verifiable scope and surround to the limits on your liability, because, for example, knowledge attribution, which I think we'll talk about, is quite narrowly defined. But I do think it's difficult because, especially if something comes up towards the end of the limitation period, or, at a period in time, say tax warranties especially seem to come up very late in the day. And as you say, the files have all gone to storage, and, the people who worked on the deal are now a bit fuzzy about it. And, in common with many of the other issues that you have with kind of witness evidence in arbitrations generally, the memory of what you put in the data room and when and why, is hard to track down. So, an aggressive claimant side presentation of a case that says, these warranties were, misrepresented or were not properly satisfied. It can be very hard at the initial stage to assess that with the client until you get to the point of everyone now having another look at what was in the data room and, what bodies are in fact buried in the various sort of email chains. But it's certainly an issue in terms of case management. But I don't think it's necessarily more of an issue in arbitration than it is in litigation. I think it's just the seller side position is always going to be difficult.
David, I think you encountered some of these issues in your recent Brazilian case. Were there particular advantages or disadvantages to getting information through the arbitral process?
I think that there are probably more, as Philippa says, it's probably much of a muchness between arbitration and litigation. In our case, we were acting for the seller, and of course, it was exactly that scenario. They had walked away. They had moved a lot of people over. They'd moved a lot of documents over. They had given the other side immense access to their data, and that was access that went on considerably after the transaction finished. And it transpired that a lot of that access had been used to try and build a case against them. It also was the case that because a lot of people had left, information was quite deficient. And there's a certain amount that can be done through your own resources to fill that in. But to some extent, you're going to be reliant, if you don't have very clearly drafted rights of access and rights of information built into the SPA, which of course we didn't, because that would have made life a lot easier, you're going to be reliant on whatever discovery and document production processes you can invoke. And I think in that context, it's important to be cognizant not just of the ordinary processes of document production and those hideous Redfern schedules with columns 1 inch wide that we all hate so much, but also the sort of external court-based processes. In the US, of course, 1782, which we all rather sort of, I think, feel annoyed that the Supreme Court has managed to escape having to have a view on. And in the UK, Section 43 of the Arbitration Act, which is quite badly written and quite unhelpful in many ways, but does provide at least some routes through to provide access at least to third-party documents if they're in the UK. So I think trying to explore those kind of options as well is important. But a lot of it also goes back to the drafting of the SPA, because one sensible thing to think about in drafting the SPA is precisely what provision you should make to be able to get documents in a dispute, so that you can end run some of the arguments that otherwise you might face about relevance, materiality, and proportionality of production requests.
So there you go, John. It's all the M&A lawyer's fault for not putting the right drafting in. Don't ever let David scrutinise your drafting, because he might have the same views as he has of the Arbitration Act. I mean, I'm guessing it's hard at the deal stage to get clients, or at least some clients, to focus in a lot of detail on the minutiae of what might happen if they end up in a misrep claim or a warranty claim down the track. But what in practice do you do, and what steps can you try to take to make sure that if those disputes arise, a seller can have an even playing field?
Yeah, I mean, I think in my world, as it were, I mean, we don't plan for these things, for disputes, perhaps when in these clauses, but you know, the general principles are retention and access. So you want to make sure that, and to be fair, these are often mutual provisions. You want to make sure that both parties have an obligation to retain and grant access, and that there will often be caveats around that. Access has to be reasonable, has to be, you know, within certain parameters around things like business hours. It can't have an impact on the business or the employees or management, for example, because you don't want the other side taking up too much of the management's time, etc. But certainly in the London market and in the international and cross-border M&A world, the inclusion of provisions around access and retention to information documentation are included. Now, often they may well be drafted in the context of ability to comply with regulatory and legal points. So, for example, things like making sure that in a few years' time you can still file your tax claims for the period when you still owned the business, for example. They're not necessarily drafted with disputes or arbitration litigation in mind. And sometimes you do actually see the opposite, which is actually people saying you can have access unless it's arbitration or a dispute, because I don't want you potentially getting in that. I don't know if that overrides rules on disclosure, I don't know, but I have seen that, very rarely, but I have seen that before. But certainly the general provisions that we see are you're allowed access, retain documents, and the access is granted for compliance with, you know, your own regulatory or legal obligations, is often the kind of reasonable position you end up, rather than just a broad brush, you can access documents whenever you want.
And I guess that reflects, I mean, it seems from the discussion so far that lots of disputes that result in the post-M&A world essentially boil down to information. It's what was the real state of affairs at the time of transacting? Were warranties untrue? Are there actionable misrepresentations across a whole sort of range of potential sectors? But a lot of it comes down to who knew what, when, was it disclosed? And as David's example of the Brazilian case sort of emphasises, also a lot of M&A transactions involve a degree of musical chairs. So people will move with businesses. There'll be an underlying business and an owner. The business will know some things. The owner will know some things. And a lot of different potential candidates who know relevant information and potentially different ways in which a seller, for example, or a buyer, to the extent somebody's arguing constructive knowledge or that the buyer knew something they claim not to, may or may not know something. And what sort of issues arise in practice in relation to that, Philippa, in terms of really among the range of actors, both corporate entities and natural people involved in a transaction, who knows what and why does it matter?
I mean, absolutely. And I think it comes down to clever drafting again. You know, there's always that balance to be struck between, you know, from the purchaser's side, wanting to make sure that they have as broad as possible a range of people deemed to be in possession of knowledge for the purposes of disclosure and due diligence, and then from the seller's side, the desire to narrow that as far as possible, so that unless it was, say, reported to the board and minuted in a board meeting, you're not deemed to know about any issue in the business, even if every line manager you have is sort of scratching their heads and going, "This is a terrible disaster." That then becomes the problem, I think, because when you come to look at a dispute situation, you have people coming and saying, everybody knew about this problem. And, you know, but the agreement says, well, the only person who needed to know about the agreement was the CEO, and it never reached his desk. And so that, I think, leads to immense frustration, I think, on the claimant side, because they feel that the agreement has been designed, if you like, to tie them in knots. And I think, you know, as John said, nobody goes into an M&A transaction planning for a dispute. And most of the time, the issues that come up later are things that might not have made a difference to the decision to proceed, but seen with 2020 hindsight are then reclad by people like us in clothing of this is appalling, and had we known, and it undermined our faith in the transaction completely, and all of the sort of lovely rhetoric that we try and deploy, but the reality is you are I think stuck with the scope of the drafting and the restrictions on what knowledge is deemed to be. And so you can have some very difficult conversations with clients to say, yes, I know you have 3 line managers who are prepared to testify to the fact that they've been complaining about this bit of kit not working for 6 months, but it simply doesn't come within the scope of this warranty, and I'm sorry.
I always feel, so often in these cases, there's a squeeze put on to the directors and the people in a business who go across. I think one of the earliest experiences in my career was hand-holding a Greek director who had come across with a business to a private equity buyer who was our client, and really sort of caught between a rock and a hard place. So potentially knew some of the things that were the basis of a fraudulent misrep claim, was in the company, was now effectively an employee of the PE fund, but was actually a neighbour of the seller and connected. And I remember sort of long hand-holding conversations, including one on Boxing Day. And first experience of sort of working with Greek and Russian clients, a call on Boxing Day where he was very keen to get everything cleared up before Christmas, which felt rather unfair to me. But they're often stuck in the middle and potentially know things or don't. And what sort of relevance do they have, David, the people who are left in the business when the buyer and seller go to war over warranty or representation claims?
Yeah, so I think that what they create is a fundamental kind of agent principle problem, because they are almost always going to be the prime sources of information for the claimant, for the buyer. They're also almost always going to be at least some of the witnesses that buyer will be putting up in any dispute. And they're obviously tremendously incentivized to say either, oh, well, this is a huge problem, but somehow I never knew about it, or, oh, yes, this is a huge problem, and I was so worried about this, and I told everyone, but they just said, oh, no, keep that quiet, don't say anything about it. And that sort of that sort of tendency towards honestly or sort of unconsciously self-exculpation is a huge evidential problem for a buyer that you sort of have to be cognizant of, both as claimant and defendant, when thinking about those kind of witnesses. Obviously, there are extreme examples where it is that individual themselves who are somehow so implicated in misfeasance that they could be the target of a claim. And that creates potential problems if you are the claimant, because you run into the sorts of in whose hands are those claims and the problems around reflective loss that we're all familiar with. But I think to me, at least at a practical thinking about how to build a case perspective, it's that kind of psychological agent principle problem that's most troubling about those individuals.
And John, from the client side, I would assume clients, and you act extensively for PE funds among other clients, they want and need key personnel and management in businesses, and so I'm assuming they place a premium on retaining the people who run the company. Do they think through the potentially adverse relationship that they might have, or the potentially strained and tense sort of situation David describes, where if they find uncomfortable things about a business, the first difficult questions might be ones being asked to their own management team who had custody of the business before they bought it?
I think they do, but obviously the reality is at that point they are employees of the PE house indirectly, and so therefore, as you say, the issue is that tension between my new employer and my previous employer. And so, yeah, they do think about it, but as we say, it's not always perhaps thought about as much as it should be in reality. And, you know, we rely very much on our usual protections around drafting, as Philip has mentioned, you know, making sure that, you know, the knowledge is actual awareness and it's limited to a very specific number of people, which may not include management. You know, it may often just be the directors, the very senior people, and it might not be even include management. And we and certainly in the UK mid-market, and once again in the kind of the cross-border M&A world, generally constructive knowledge, imputed knowledge is completely removed. There's none of that. It's actual awareness. That said, there's always room for manoeuvre, and sometimes you do see provisions around along the lines of actual awareness of, you know, these senior people, but they must have made reasonable inquiries or certain inquiries of certain people, whether it's the head of division or head of a certain business unit. So there's a spectrum of what's available for buyers. And one other interesting provision that I certainly always insist on if I'm acting for a buyer is that the seller can't bring any claims against my new management team, the one I've just bought. So I can't bring any claims against the previous management as a seller for what they've done in terms of their diligence, their disclosure, for example, other than, of course, fraud. So unless that person has acted fraudulently, I can't bring a claim against them. So that as a buyer helps me protect, obviously, the business and my new management team. So that is probably one of the key things that we do as a buyer on the buy side to try and protect that management team you just acquired. But of course, fraud you can't disclaim, obviously.
David.
No, I was just going to do something which is perhaps not sort of the done thing at one of these talks and admit ignorance, because something that you said, John, triggered a thought, which is there's a general principle in agent and principal relations that you can be made vicariously liable for the acts of your agent and for the dishonesty of your agent, and that can include where the agent makes a false statement that they don't know to be false, but which you know to be false, but you've deliberately kept the agent in the dark so that they can make that false statement. And I think it's interesting, and it may be that others in the audience have experience that can shed light on it, which is how that agent-principal concept interacts with the sort of limited contractual set of individuals who can be seized with knowledge. Because that almost allows that situation to arise. It allows you to put a group of people in a world where they're kept in the dark and sort of, you know, allowed to think what they like, and the rest of the business carries on saying, oh, well, we just won't tell X, Y, and Z. So maybe it's a point for questions if people have encountered that and the interaction between that rule of law and that set of contractual principles. But I think that's potentially an area of tension where some of those contractual rules could cut across some more sort of basic principles. I'm sorry I interrupted you, Will. I was just
No. Well, a slight change of direction. I mean, John, you outlined for us very helpfully some of the issues your clients are thinking about. I suppose one of the things we all like to know. David, Philip, and I are in disputes-only practices. So one of the things we miss out on these days is the opportunity to speak routinely with our transactional colleagues, and in particular, to use the opportunity to try to put arbitration clauses perhaps into agreements where they might not otherwise go in. And if we're lucky, to try to put Mauritius and places like that as the venue of arbitration, looking to the future. Those days have sadly gone. And one of the things, speaking for myself, I suppose I've lost as a result is a sense of the appetite for arbitration when people are looking for arbitration clauses, and also what else are people doing when looking at their dispute clauses that is either embracing arbitration or looking at other ways potentially to avoid arbitration. And I know your practice, a lot of your work is in sub-Saharan Africa, which would seem a sort of area where arbitration could potentially play a role. But what do your clients think about? I mean, who has an appetite for arbitration and why?
Yeah, I mean, I think once again the obvious point to make is that for a UK deal with UK assets, UK companies, and obviously English law, English courts is very much the trodden path. Where arbitration, I see it most often, as you've intimated, is in cross-border M&A, particularly in emerging markets. So in Africa, in the Middle East, where to be brutally honest, the courts aren't as developed, and international investors do have concerns about being trapped in litigation in, say, the Nigerian courts, for example, or others for many, many years. And so arbitration is seen as a relatively fast, efficient way to manage any disputes. Obviously, there are exceptions to that. The courts in South Africa, for example, are very well respected, and Kenya as well, for example. So it's not a binary rule per se, but certainly. We do see it where you have, investors or counterparties from different jurisdictions, and the target assets are in maybe an African jurisdiction. And I see London, obviously, LCIA, ICC as probably, given that obviously a lot of my contracts are under English law, it's probably the more common dispute arenas I see. But the IFC is another one that I see quite a lot, because particularly in North Africa, given the proximity to the UAE, for example. So yeah, I say the arbitration I see the most is in cross-border M&A, but when you have a deal that's done within one jurisdiction, one country, people tend, I think, to stick to their local courts as a general rule.
And is there a role, and this is probably not a popular thought in this room, but a lot of disputes coming out of the back end of an M&A deal are about accounts. They're about what the business was worth, their EBITDA multiples, they're calculating earn-out and disputes over earn-out. Isn't there a role, Philip, I'll ask you this, isn't there more of a role for expert determination in these sort of situations? The issues are, what do the numbers say? What's the adjusted EBITDA? Therefore, what's the earn-out number? Get an expert to do it. Isn't there more of a role for that?
Would that it were so, Will, because you and I both know that what happens in reality is that when that kind of issue arises, there are a plethora of other legal issues around them. So before you get to the point of saying, what do the numbers say, you need to go through the hoops of who knew what when and how, and why has the nature of the business changed, and why do the numbers not match with what both parties expected them to, because the whole point of an earn-out is that everyone kind of assumes that things will continue in steady state, and if they haven't done, the reality is that one side is going to be saying, well, it's somebody's fault and it bloody well isn't mine. So I think that's the problem with expert determination, because the questions by themselves, as you say, are perfectly reasonable and absolutely appropriate for someone who actually has a head for numbers, unlike most lawyers, to go and deal with. But what so often happens, and I've certainly had it happen in practice, is that you put in an expert determination mechanism that is then unsuited to the underlying character of the dispute that arises. And so you end up in what I like to call the Wild West, because experts don't have to give reasons either. So you get an answer and you have no way of explaining to the client how that answer was arrived at. And it can cause, I think it actually causes more trouble in some ways than it's worth. So you could say instead, once you get to a point where you've got a decision on liability, then absolutely quantum can be hived off and submitted to an appropriate person to deal with. But I think what happens in practice is that expert determination mechanisms are often unsatisfactory for both parties in reality.
And a final thought then, if experts aren't the way ahead, David, you mentioned W&I insurance, which is a concept I'm not terribly familiar with, but John has explained it to me in advance, and does sound to me like an unfortunately fairly robust and increasingly popular way of making sure post-closing disputes don't go to arbitration. John, for anybody else's benefit who's not as familiar with this market, could you just tell us a little bit about how W&I insurance works and why it's popular?
Yeah, of course. So warranty and indemnity insurance, or W&I, is a very common product that is used in M&A. It's not a new thing. It's been around for quite a long time now, but it's particularly mature in the UK, the US, and Australia actually as well. It's a very common product you see. So on the deals we do in Arbitral Goddard, I say about 25% of our M&A deals have it. On the PE side, it's up to maybe 50% use it. So what is it? It's a policy whereby basically the insurer stands behind the warranties that are given by the seller, which allows the seller to pretty much walk away from the transaction, well, in theory at least, walk away from the transaction with its liability capped at £1. And the buyer would then have any warranty claim to be against the insurer. it sounds great, obviously, in theory. In practice, like any insurance policy, whether it's your car or your house, there are exclusions, there are caveats, there are retentions, and all the other things. So, so for example, it will never cover things like environmental risk, health and safety risk, compliance risk. So there's always gaps in it. So it won't completely remove the need for you or your colleagues here, because there'll always be other claims that aren't covered by it. That said, what I don't know, because I don't look at the other side of the curtain, is when there are disputes between a buyer and an insurer, because of course there'll always be debates around whether something is covered by the policy, and so that inevitably there must be disputes between buyers and insurers now. And ironically, insurers actually like to, when they are marketing, to say we do pay out on claims. So actually, last year we paid out on X number of claims as a way to make sure that people, because there is that perception in the market that it's basically a way of the seller walking away with the buyer having recourse to this product which perhaps isn't as great as it might sound. But as I say, it's very common in our world, particularly in the private equity market, because it allows PE funds to walk away, have a clean break, in theory.
Well, it's probably not one for today, but a whole new question about information between buyer, seller and insurer, potentially. Mindful of the time, I'm looking at Tom. I think Tom's been collecting questions, which I know the panel will be glad to address.
Yeah, thank you very much, guys, for that really engaging discussion, and thank you to everyone who also has been submitting questions. There's been quite a few, which is a good thing, but in the interest of time, I'll pick a couple which perhaps were a bit less discussed on the panel. The first one is, have the panel seen litigation finance used in M&A deals? We have seen deals where litigation finance is provided in a deal or where funds buy claimants.
Not from my side. I haven't seen litigation funding used, but clients are increasingly interested in it, and I wouldn't be surprised if it forms part of an overall strategy in the future.
For my part, I haven't seen it taken up, but it's something that has been discussed with claimant side parties, in the sense of, do you want to do this on your balance sheet, or do you want to essentially monetize this dispute up front? Haven't had any takers, but I can definitely see it happening.
Brilliant. Anyone else on that one before we move on? No. Have the panelists experienced any particular concerns when dealing with M&A in the technology sector?
I think the main concerns are around data and data protection. Personal data are probably the main risks, and I think, as I mentioned earlier, cyber breaches are some of the main things that you worry the most about in tech deals. And the simple answer: who owns the data? We have a lot of businesses that claim to own a lot of data, but as we know, companies don't own the data necessarily; they process it, etc. So I think it's understanding from a diligence perspective, when you're buying a company that claims to be very data heavy, what right does it have to that data? Probably some of the main concerns you have when you're diligencing a tech and data heavy business.
It looks like we've got time for a couple more, actually. Have the panelists experienced reluctance from parties to M&A transactions to incorporate arbitration clauses on the grounds of cost or for any other reason?
One for you, John.
No, not at all. No, I think no objection. I think, as I say, people in the UK will obviously look at the English law, English courts, but particularly sophisticated investors in international and cross-border M&A see arbitration as a very reasonable and acceptable dispute resolution. I mean, costs certainly have never been raised to me as an issue. So no, I wouldn't say that's come up in certainly my world, no.
And there's been a couple of questions on W&I insurance. Do you feel the growing trend of obtaining W&I insurance in M&A transactions is taking the heat out of warranty negotiations and consequential disputes?
It's not a good. It's a good question. Sorry, I think it does in some respects, because it allows the seller to think, well, that's a set of warranties, I don't need to worry about it. But the reality is for an insurer to insure that set of warranties, a buyer needs to demonstrate to that insurer they've done enough diligence. So actually, it does shift the perspective a bit more to the buyer, and the buyer having done its diligence, because an insurer will not underwrite that product, that policy, unless the buyer can demonstrate that it's done its diligence. And I, as a buy-side lawyer, will go on what's called the underwriter's call the day before signing, and the underwriters will basically ask me point blank, are you comfortable with the diligence that's been done and the disclosure process that the sellers have done? Because obviously the sellers might not be very incentivized to do a full disclosure process. So I have to basically make sure that we have done that, and I'm comfortable that the sellers and the management have done that exercise. So it does shift the emphasis.
And I think there's another point which John, you'll probably know much more than me about. But as I understand it, most W&I policies include a waiver of the insurer's right of subrogation. So the insurer can't sue against the seller for breach of the warranty that it pays out on. But usually that waiver is subject to an exclusion for fraud. So if there's a fraudulent misrep in the warranties, then that can still give rise to a subrogated claim. And I think one can imagine a scenario where if insurers feel they need to police buyers, you know, if it looks like buyers are essentially free riding off insurers, then you can imagine worlds in which WI insurers will invoke their subrogation rights and bring claims. But those claims will tend to be at the sort of extreme end of the scale where you have outright fraud in the due diligence process, essentially.
I agree with that, yeah.
Okay, brilliant. Well, in the interest of time, I think we should be moving on to our next panel, but I hope everyone will join me in thanking the panellists for a brilliant discussion this morning.
Thank you.